Yes, Bobby Banson.
Before Bobby speaks, let me just make a statement. I take the very respectful position that when a judge makes an order and says that there should be a rerun in a particular constituency, consequential to that order is a vacancy.
Okay.
In law.
Okay. All right.
Consequential to it.
All right. Let me go to Bobby now.
Yeah, listen to Bobby.
Hi, Bobby.
Good morning.
Good morning.
Samson.
Yeah, I understand that you are going to teach very soon, so speak to us. Straight to the substantive matter.
Senior Kwame, I always love to hear him speak.
Thank you.
You know the way he does it, both in the courtroom and outside the courtroom.
Chew your speech already.
Yes, Samson, yes, your question.
Yes, so I'm asking, having heard him,
no, this is my notebook.
Do you think, people are asking very basic questions, that we have precedents of these issues having happened, but there was an allowance for the judicial process to be exhausted before a vacancy was declared?
Yes, Samson, I'm happy that you read the constitutional provision. I think that we must have this discussion in the light of the petition that was filed to the High Court, the orders made by the High Court judge, and the subsequent processes that have been filed, all in the context of the provisions in the Constitution, which is the foremost law, and the Representation of People's Representation Law, have it now. I think that if you read the judgment of the court, the judge ended by saying that it is in the light of the various written submissions that I hereby order a rerun of the Kpandai parliamentary election to satisfy the constitutional requirements of free and fair and transparent election result. Now, that was the definitive order made by the judge. However, if you look at the reliefs that the parties were seeking, like Senior Kwame just mentioned, there is no way the judge would have ordered for a rerun unless the judge had granted the previous declaratory reliefs that the petitioner sought in those suits. And those declaratory reliefs essentially saying that there had been irregularity that had been so fundamental in the organization of the elections that there is a need for a rerun, and the judge explaining why he thinks that the argument of the petitioner must hold, concluded by ordering a rerun. Now, per the constitutional provision, once this is done, Parliament is notified, the clerk then writes to the Electoral Commission. This is a constitutional mandate that process must be undertaken. And as Senior Kwame said, in the most recent cases of the former Chief Justice, Justice Torkornoo, the Supreme Court seemed to have emphasized without any doubt that where there is a mandate placed on an institution by the Constitution, that mandate is not suspended unless there is an express order so to do. And so if you look at what the Clerk of Parliament did, by writing to the Electoral Commission, letting the Electoral Commission know that they've been served with this order, my understanding is that the clerk was following due processes or obligations, carrying out an obligation imposed by the Constitution. If you look at what the Electoral Commission did, that they have announced that there will be a rerun, then you would say that Electoral Commission is also carrying out their constitutional mandate. However, if there have been judicial processes that have been filed that seeks to restrain the carrying out of these constitutional mandates, the question is twofold: whether it is legal for this mandate still to be carried out in the light of the pendency of the of the court processes, and second, whether or not it is, Senior Kwame used the word prudent, to still carry out these mandates in the light of the provisions. Now, Samson, if you look at the certiorari application that has been filed to quash all the proceedings leading to the judgment and the judgment itself, the argument being made, and I don't know if the Electoral Commission has been served, if the original petitioner, who be the interested party in the certiorari, has been served, the argument being made that the petition was filed outside the time limit provided by Section 18 of the Representation of People's Law. And so if that actually is upheld, it means that the petition was filed was a nullity. The processes filed leading to the judgment itself was a nullity. Everything that had been done by the court itself is a nullity. Now, if the Electoral Commission proceeds to order a rerun on the 30th, and the certiorari application finds favor before the Supreme Court, and the Supreme Court quashes all the processes leading to that judgment and the judgment itself, what happens to the rerun if a new person has been elected by virtue of the rerun? We are going to find ourselves in a constitutional crisis. I am aware that the return date for the certiorari is the 16th of December. I expect that on the 16th, the Supreme Court may be moved by counsel for the applicants in the certiorari application for the Supreme Court to order the Electoral Commission to stay the carrying out of the rerun on the 30th, pending the outcome of the certiorari application. That is, if the certiorari application would not be determined on the 16th and it has to be adjourned. I think that we must also commend the judiciary for giving such a short date to the certiorari application so that it will, to all intents and purposes, be heard on the 16th before the 30th December, which day the Electoral Commission has put across. So I think that there has to be a legal question that has to be answered. My position is that it's looking at the decision by the Supreme Court in the Torkornoo case, it seems that there will not be any constitutional restriction on EC or the clerk carrying out their duty. But on the side of prudence, the side of prudence and the consequences, if they proceed with the rerun and the certiorari in particular succeeds, what will happen if a new MP is elected by virtue of the rerun? The rerun is based on a judgment that the Supreme Court may subsequently order to be a nullity. We'll find ourselves in a constitutional crisis.
Why constitutional crisis? The court will simply say that the judgment of the High Court is vacated, and therefore the status quo before will remain. Yindam will simply go and continue his work, even though we would have wasted if we spend up to 38 million, would have wasted 38 million organizing fresh elections.
That's a lot of money, but I'm talking about the crisis in the event that if the decision on the certiorari is not delivered before the 30th, a new person other than the MP who is the subject of the dispute is elected. He is sworn in by Parliament. He goes through all those legal processes. Now, Supreme Court says that the judgment based on which there was a rerun is a nullity. It means that that person who will now be affected by the Supreme Court decision, but was not originally made a party to the certiorari application, would also have a recourse. That is the crisis I'm talking about. Because if a new person is elected, the decision on the certiorari will affect the person now. But that person will not have been a party to the original certiorari application, because at the time the certiorari was heard, he was not yet elected. And so it's looking at all these matters. It may be in the interest of justice, because justice must not only be done, it must be seen to be done. And to avoid some of these pitfalls that may occasion if the rerun proceeds prior to the delivery of the ruling in the certiorari, I think that the applicants may have to move the Supreme Court on the 16th. That is, if all the parties have been served with the certiorari application, and if the Supreme Court is not going to deliver a ruling on the 16th, pray the Supreme Court to stay or order the EC to suspend the rerun until the outcome of the decision in the Supreme Court.
Okay, as I understand, the EC, they have been served, they have responded, and there is an application in the direction of what you are suggesting to suspend
in the Supreme Court.
Yes, to suspend the direction for 30th rerun pending the hearing and conclusion of that matter. But from what you suggested, as we understand, the 24th December date, Gazette, that appears to be a question no longer in doubt, as confirmed by the Electoral Commission and previously by the Supreme Court in the Akwatia, election dispute matters. So from where you sit, does it not look most likely that the courts will as it were, uphold the argument by Matthew Yindam that the Tamale High Court did not have the, jurisdiction to hear the matter?
Well, Zamzi, we can only speak to the law as we understand it, and the facts would have to, but we will leave the conclusions to the judges. Otherwise, we may be cited for attempting to discuss. But like you said, if there's no doubt from the previous decision in the Akwitia MP case, and you see the counsel, Garini Makun, was also cancelling the matter of Eneskumi.
That's right.
In the Akwitia MP, where he argued that if the 24th is the day of the Gazette, then per Section 18, the petition ought to be filed within 21 days. And if it is 21 days, if you look at the Interpretation Act, includes Saturdays, Sundays, and holidays. Because the Interpretation Act says that if a statute requires a thing to be done, and that thing ought to be done for days less than 5 days, then it excludes weekends and holidays. But if it is more, it includes weekends and holidays. And it says that 21 days from the date of the Gazette. It means that you start counting the 21 days after the 24th. So even though the 25th is a holiday, by virtue of the Interpretation Act, it will be calculated, and all other holidays along the line and all other weekends will be added. And if you add all of those, you ask yourself whether the petition was filed within the 21 days. The Supreme Court has made it clear, where a statute provides for timelines, and you miss those timelines, you cannot invoke the jurisdiction of the court. And so it's a question that you would have the Supreme Court applying the law as they have in the past.
So your wish is that we slow down, or as it were, Parliament and the EC slow down. However, the way to get things slowed down to 30th of December ought to be by judicial means. That's what you are saying.
That is what I think, that the Supreme Court must make a definitive pronouncement. Because you see, hitherto, we had thought that the mere filing of a certiorari, if you look at cases like Ioko, the mere filing of a certiorari operates as a stay of execution until the Torkornoo decision, where Justice Kulendi made that point, and forcefully so, that when we do that, constitutional machines may be grounded by frivolous applications, for lack of a better word. And so you'd have the Supreme Court having the need to go the extra mile and making definitive pronouncement that as long as this certiorari is pending, they are ordering the Electoral Commission to stay their hands until the final determination for all the reasons that I have sought to submit.
Thank you very much.